7 o'clock. I think I'll call the meeting to order, please. Welcome, everyone. Are there any considerations of additions to the agenda that we need to know?
Michael Harvey with Current Planning, just to bear with me for a minute. So good evening. You have a set of minutes at your table. We did not include them in the packet because we quite bluntly didn't think they would get done. They did. We're not asking you to take action on them tonight. To clarify for the board members, the April 16th, 2018 meeting, we had identified a full board being present, including at that time both alternates, Mr. Herman, Ms. Safi. I had a discussion with Ms. Barrows, who I had indicated we had a full board and we did not need her that evening if she chose not to show up, and advised her, since we were going to have this special meeting come May the 7th, that her attendance, while always important, wasn't necessary. And she obviously elected to let Ms. Safi, Mr. Herman sit in their capacity as alternates for last month's meeting. So just to clarify that Ms. Barrows' absence was indeed excused, but it was excused because we already had a full board complement at the time. Also to clarify, Dr. Katz's attendance was also excused. He was out of town. So both absences were excused. As a general reminder, we're here tonight to review an appeal. I'm going to get into some specifics in a minute, but a general rule is you must treat the microphones active at all times. If you need to have a moment to yourself, my suggestion is you push your chair away from the microphone. Fair enough? All right.
Thank you, Michael. Susan, do you mind reading the public charge, please?
Certainly. The Board of Adjustment pledges to the citizens of Orange County its respect. The board asks its citizens to conduct themselves in a respectful, courteous manner, both with the board and with fellow citizens. At any time, should any member of the board or any citizen fail to observe this public charge, the chair will ask the offending person to leave the meeting until that individual regains personal control. Should decorum fail to be restored, the chair will recess the meeting until such time that a genuine commitment to this public charge is observed. All electronic devices, such as cell phones, pagers, and computers, should please be turned off or set to silent vibrate. And do we need to continue that? No.
Thank you, Susan. Are there any that wish to speak tonight that need to come forward and be sworn in?
Madam Vice Chair, as this is an appeal, you have two attorneys who are going to be presenting arguments to you concerning the issuance of subpoenas. There will not be a need to swear in witnesses unless the attorneys for either party indicate they have people wishing to enter testimony into the record.
Correct. If there is no one, Michael, would you just like to tell us what we're up to?
Very briefly, this is the convening of a hearing to begin review of appeal application concerning an October 13th determination made by the planning director. You will note from your abstract that the attorneys for the applicants as well as impacted property owners have filed a joint request. That's contained in attachment 2, beginning on page 66 of your packet. That the board first review issues associated with the denial of a subpoena request by the vice chair. That is the sole discussion point for this evening. Both attorneys have requested that after you've made a decision on the subpoenas, that action on the appeal in and of itself be delayed to a future meeting.
A future meeting by the planning board? By the Board of Adjustment?
Yes.
So we're going to hear this again?
You're going to hear the merits of the appeal. Yes, sir. tonight's decision will only be on the issuance or non-issuance of the subpoenas.
Okay.
I would just like to state that the reason I decided not to sign these subpoenas was the fact that Barry and Susan and Matt, tonight we're lucky enough to have Randy, have heard quite a bit of discussion and testimony and so on and so forth about this issue. And I felt like they should be involved. I knew if I refused, it would come back to the board. And so here we are to get their input as well.
So just to summarize the abstract, attachment 1 is the appeal application and subpoena requests. That begins on page 3 and goes to page 65. Attachment 2, as I've already alluded to, which begins on page 66, is the joint correspondence concerning review of the subpoena requests. And beginning on page 70 is the excerpt of the session law. The background of this is as follows and is articulated in the abstract. On July the 12th, session law 2007-108 became effective, which established criteria for the use of structures on a bona fide farm or agritourism events. We received a request on October the 12th from Mr. Andy Pettish, who is here representing the Barn of Chapel Hill Wildflower Farm, for a determination from the county as to whether or not the property met the requirements of the session law and could conduct agritourism activities. As you all know, and as articulated in the abstract, this request involved the structure located on a parcel of property identified utilizing Orange County Parcel Identification Number 9729-50-7168, owned by Southeast Property Group LLC, also known as Wildflower Farm, and is commonly referred to as the Barn of Chapel Hill. The request was reviewed with Mr. John Roberts of the County Attorney's Office. After review of this request, staff made a determination the structure located on this property, as I've already identified, is classified as a bona fide farm pursuant to the provisions of North Carolina General Statute 153A 340B2A. It is not subject to land use regulations as embodied within the Orange County Unified Development Ordinance. Ms. Brown has attached a copy of our letter with an attachment 1, which is the appeal application. As part of the submittal, Ms. Brown, who represents several adjacent property owners, had requested the chair, under their discretion as per local land use regulations and state statute, to issue subpoenas for requested information. That request, as Ms. Barrows has articulated, has been denied. Per the request of Ms. Brown, the full board has been asked to review that denial and determine whether or not the subpoena should be issued. In conclusion, in terms of staff presentation for this evening, I will remind you that the attorneys for both parties, specifically the applicants, appealing the staff determination and the denial of the subpoenas, as well as Mr. Pettish, who represents the owner of the Barn of Chapel Hill property, have requested that the purpose of the meeting is to allow testimony in the issuance or denial of subpoena requests only. That while this meeting is open to the public, participation is limited to those parties that have standing. And that last but certainly not least, that the decision to issue or not issue the subpoena is ultimately appealable to Orange County Superior Court within 30 days. Unless you have any specific questions for staff, I would like the board to take action to enter my abstract packet, including all 3 attachments as I've reviewed them, into the record, and then allow Ms. Brown and Mr. Pettish to address you all.
I move that we enter Mr. Harvey's packet into the record.
Second.
Barry, second. All in favor, please say aye.
Aye.
Aye. Any opposed? We will give the attorneys 10 minutes each. Leanne, if you'd like to start.
Thank you very much, and I think that that's all we will need. I appreciate the opportunity to appear before you. Would ask you so that I do not require to put on evidence as to people standing. You take judicial notice that you found that my clients have standing with regard to this matter and several prior matters. The There is a procedure in the Board of Adjustment statute that is designed to add a means by which information that may be relevant and material to a hearing can be obtained, and that is the subpoena process. Subpoenas, as a general principle, are means by which documents or other things are brought before a tribunal. You're the tribunal here. Admissibility of that information, whether that information should be admitted into a subsequent hearing about the matter at issue, is decided in the context of the hearing. But the subpoena is the means by which the documents can be obtained, and they can be looked at to obtain information that advances an action. The issuance of subpoenas generally is a ministerial act. It initiates proceedings to have documents come before you. And there's case law in North Carolina that says that. I'll quote Bone v. Broadfoot to have a case in the record, but there's a plethora of it. The word relevant in the statute is also informed by how the word relevant is described in the rules of evidence. You will recall you apply relaxed rules of evidence in your hearings, and NCGS 8C-1, Rule 401, defines relevant evidence as evidence having any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. And that's all it requires. The comments to Note 401 state that dealing with probability in the language of the rule has the added virtue of avoiding confusion between questions of admissibility and questions of sufficiency of the evidence, and has also subsumed in it the concept of materiality. NCGS 168-388G, which is a statute that governs you, is quoted in pertinent part on page 52 of the packet in my letter to Samantha Cabe seeking the subpoenas on November 7th, 2017. And what NCGS 168-388G allows is it allows persons with standing to seek subpoenas. The procedures to give you a written request, which we did by letter with subpoena documents for each person and for documents we asked to be subpoenaed. And it provides that the chair shall issue the subpoena if it's determined to be relevant, material, and reasonable in nature and scope and not oppressive. The statute also contemplates that parties from whom documents are sought may file motions to quash subpoenas. There were no motions to quash or modify filed in connection with the request we made some 6 months ago. So what occurred here? 6 months ago, we provided a letter notifying the staff of an appeal of the decision of the current planning supervisor dated October 13, 2017. It's the appeal Mr. Harvey addressed. Pages 49 to 51 of your record outline the errors alleged. The letter to Samantha Cabe that I sent sought 5 subpoenas. They are to the following parties. They are to Southeast Property Group, LLC, which is the legal owner of the property. There is one to an entity named Wild Flora Farms, LLC, which was created at some point in time. There was one to Kara Brewer individually and to Chris Brewer individually, and one to the Barn of Chapel Hill, LLC. What we hear is those names used interchangeably to all mean the same entity, but under the law, those are all separate legal entities. And what we sought from them was information submitted to the North Carolina Department of Revenue or to Orange County regarding their alleged eligibility and alleged compliance with the statute regarding the farm exemption as it has been amended. That statute can be found in NCGS 153A-340. Michael talked about it as a session law, and it is a session law, and it amends several different places in the statutes. It contemplates that someone can obtain a certificate from the North Carolina Department of Revenue under NCGS 105-164, Port 13EA, and not B, which is an important point I'll get to in a moment, or 105-277.3. The other thing we sought was information regarding the relationship among these entities, because there is information that has been provided to the county in the letter to which Michael responded, which suggests that a tax certificate that was received that identifies Wildflower Farms, just Wildflower Farms and Cara Brewer, somehow applied to Southeast Property Group LLC. The statute refers to the owner of the property qualifying for the certificate. And one of the errors that we have alleged is that a certificate addressed to Wildflower Farms or Cara Brewer cannot, at least certainly not without looking behind it, which is what I'm trying to do with the subpoenaed documents, cannot apply to Southeast Property Group LLC. On its face, it does not. The other concern we have, very frankly, is that the income amounts and the time increments that are included in the two statutes regarding the North Carolina Department of Revenue do not appear to be possible temporally to have been met. And so we think the information that was provided is helpful to inform us as to whether there is, in fact, compliance with those issues, which would be the issue before you when we come back again, because I do love appearing before you. So, and I know you love hearing about this. What the statutes require, and I just want to review it with you briefly, is a certificate under 105-164-13EA, or enrollment in the present use value program under 105-277.3. 105-164-13EA requires an annual income from farming operations for the preceding tax year of $10,000, or an average for 3 years of $10,000, and that's where the temporal concerns come in. 105-164-13EB gives conditional exemptions for tax purchases. That does not qualify you under the provisions in Chapter 153. As I said, the NCDOR letter to Cara Brewer with an exemption ID number for a Wildflower Farm, and it's dated 9/22/17. Wildflower Farm was created in February 14th, 2017, so it didn't exist but a few months. If it's the LLC, there is in your record an assumed name certificate for Wildflower Farm and Southeast Property Group, but it's after the appeals were taken, or after the certificate was issued as well. The property was purchased in 2015 by Southeast Property Group LLC and has been owned by it throughout this process. I found the date for the assumed name certificate. I had my finger over it. It was 10/12/17. Sorry about that. We believe that in order for you to make an intelligent and informed decision on the appeal in chief as to whether Orange County has misinterpreted what it has received or has failed to make the appropriate legal distinctions among the parties that the law would require, would be informed by the requested subpoenas. We believe that without the information, it is very difficult for my clients in the dark, without underlying information, to know whether what has been provided meets the statutory requirements. At a hearing on this matter, any evidence that is obtained through the subpoenas can be objected to. You can choose in a hearing to sustain the objection, and I can ask to make an offer of proof and have that information available so a court can look at it later. Or you can choose to receive it and the other party can object and a court can look at that later. But if I don't have anything, if I'm not allowed to subpoena the information, then it renders it very difficult under my client's due process rights to come before you and to have an intelligent argument before you as to the situation. I do not believe, I appreciate, Ms. Burrows, the situation you found yourself in, and I'm glad that you wanted the remaining members of the board to enjoy the process of hearing me speak tonight. So that's I understand that. What I would submit to you is that it would be error indeed for the Board of Adjustment to refuse to issue the subpoenas to allow parties to obtain information that meets the relevancy definition under existing law. and which renders them unable to make, to present a case to you or to make an offer of proof to you. And without that information, if we have that appeal and it goes up, then a likely outcome would be the court would send it back and say, well, let's see what the offer of proof would have been. So what I'm asking you to do tonight is to simply issue these subpoenas. And once the subpoenas are issued, the subpoenas contemplate that we will receive the documents in advance of the hearing, and that the people to whom they belong will be present at the hearing if there are questions about them. And then we can proceed at that point, and you can make the more difficult decisions about what does and doesn't come before you. But again, I think that under the statute that it would be error for you not to issue them, and we don't need yet one more thing to appeal. In this case, I'd like to have just one nice package to go somewhere at some point. So
Thank
we
you,
ask you
Leah.
to issue them. Thank you.
Andy?
Good evening. Andy Pettish, the Wake County Bar, on behalf of the subject property owners, Kara Brewer. The actual property owner now, however, is Wild Flora Farm, LLC. There was a merger between Wild Flora Farm, LLC, and Southeast Property Group back in February of this year, and I can hand up those documents right now.
Has Ms. Brown been provided a copy?
Thank you, Andy.
Thank you.
I'd like to offer that into the record. So that, just to clarify at this point, that it's Wild Flora Farm LLC that owns the property. So to jump into this, this is not a complicated decision. There's not a need for this vast amount of, potentially vast amount of documents that are being requested here. The letter that was submitted on October 12th on behalf of, at the time, SPG, Wild Flora Farm, and Kara Brewer included and requested that Mr. Harvey make a decision, included the exemption certificate that's included on page 11 of the packet, as well as the deed at the time, which was owned by SPG LLC, Southeast Property Group. Now, by operation of law, that's now owned by Wild Flora Farm LLC. An annual report submitted by SPG showing Kara Brewer as a lone member, and a certificate of assumed name at the time while SPG and Wild Flora Farm were working on that merger. SPG operated under assumed name of Wild Flora Farm. Now, you have to keep in mind that this new provision, I mean, this was a subject of a lot of debate about what agritourism and a bona fide farm purpose was before this board, a number of hearings. And in July of 2017, as was mentioned earlier, the General Assembly tried to clarify that, and they created a very straightforward compliance under the statute for a bona fide farm to conduct agritourism in a structure or building on a farm, and that is located at the end of your packet under 153A 340, subsection B2A, and it states that a building or structure that is used for agritourism, it goes on to describe agritourism later in that paragraph, which includes weddings and special events, is a bona fide farm activity, a bona fide farm purpose, if the building or structure is located on a property that is owned by a person, of course, legally a person can be an entity or an individual, who holds a qualifying farm sales tax exempt certificate. So the same person that, whether it's an entity or an individual that holds the certificate, also needs to own the property. Well, that creates in some cases, that may be a straightforward, Joe Smith owns a property, he has a certificate, but many farms, many organizations have different entities for different aspects of their operations. And so that's where Southeast Property Group, Wildflower Farm, Cara Brewer had to resolve some of those inconsistencies because this statute didn't exist. That process went forward. That has all been brought into alignment. Those documents have been presented to Mr. Harvey, and that's all there is to this case. At this point, Wildflower Farm and Cara Brewer hold their certificate. Wildflower Farm owns the property. There is absolutely no need to go into all these other document requests. That is burdensome. And again, the requirements under 168, 388G, which Ms. Brown addressed earlier, relevant is what she focused on, but it's also reasonable in the nature and scope. The question here, what they asked for, was to be able to go behind all these other documents and look at personal financial information, confidential financial information, tax records, some of the most core privacy issues that people have, and want to be able to dig through that, looking for some issue, whatever they're going to find, to continue this fight against this property. It's an overreach at this point. Mr. Harvey had those documents, and this board's job in reviewing is to stand in Mr. Harvey's shoes and say, you have all the powers that he has now. You stand in his shoes, and you get to look at that decision fresh and say, here's what they submitted. Is this enough? Does this meet the statute? You don't need anything else because we didn't submit anything else. If you don't agree, you can say, that doesn't meet it, and we'll reverse Mr. Harvey's decision. That's it. There's no need to go into what's the legal relationship between Cara Brewer and her husband. That's invasive, that's burdensome, that's oppressive. That's why this subpoena request should be denied. We're talking about, there's a list of entities in here that haven't even been involved, haven't been raised. KB Designs and other organizations, other entities that are related to this, but that hasn't been brought up at any point in these proceedings. So, in closing, this board's authority is to review the decisions that the planning staff make with respect to enforcing the UDO and specific statutory guidance that informs that. To go out and start looking at what the Department of Revenue is doing and whether they made the right choice, that's completely outside the scope of this body's authority and would be an abuse of discretion. So I ask that you deny the motion, deny the subpoena request, uphold Vice Chair Barrow's denial, and let us move on to the merits of this case. Thank you.
Thank you, Andy.
Could I just be heard briefly in rebuttal?
I don't think we were going to entertain rebuttals. Appreciate it.
I object. The
Right.
chair said 10 minutes aside. And
That's what that
May I
was.
at least point out that he misspoke on the date of the document he gave you. It is dated February 19th, 2018.
I saw that.
Thank you.
Thank you. Do board members have questions of staff or lawyers before we close the?
I have some questions that I'd like to ask.
Okay, Randy.
I guess I'd like to start with Mr. Pettish quickly, because I wasn't present on any of the previous hearings on this matter. Do you agree with Ms. Brown that this board has made a finding that the challengers have standing?
I would object to any finding of standing in this case. I've reserved that at prior hearings.
All right. And then I'd like to speak specifically on 153A 340 B2A, which is the agritourism provision. It says under subsection 1 specifically, as you stated, that the building is a bona fide farm purpose if it's located on property that is owned by a person who holds a qualifying farmer sales tax exemption certificate. The certificate that has been issued in this case is issued to Kara Brewer, and the person that owns the property is Southeast Property Group, and now I guess Wild Flora Farm LLC. Those are obviously not the same person.
But I would submit that the certificate is actually issued to Wild Flora Farm. On the card that's here in the corner, it says exemption ID 718574 Wild Flora Farm, and then the addressee is Kara Brewer, and the letter simply addressed to Kara Brewer, but the card itself is issued to Wild Flora Farm.
So you would say that the holder of the card is Wild Flora Farm, but without the LLC? How are we to know that's the same entity or person?
That would be a matter that this board would have to decide at a hearing on the merits.
Thank you. Ms. Brown, I have questions for you.
Yes, sir.
I don't want to hog the time if anybody else has anything. All right. So I'd like to go back to the standing question again quickly. You submitted that this board has made a finding that your clients have standing, which of course they're required to do in order to request subpoenas under the statute. Mr. Pettish says he doesn't agree with that. I obviously wasn't here at any of the previous hearings. Was there a specific finding that your clients have standing, or has the board just treated them as if they did without making a finding?
There was detailed testimony in one of the earlier hearings from each of the individuals that are my 6 clients, and the board made a finding of fact that they are people with standing. Mr. Pettish has appealed that to Superior Court. That appeal is kind of out there somewhere. As the statute has changed and we continue to sort of move back and forth with what this case is doing, I think at some point Mr. Pettish and I have to figure out what to do with all of the many different ways in which this case has presented. But this board has made that finding. I can certainly spend a couple of hours and put these folks up here again so we can talk about standing. But I think in the interest of time and in the fact that there are 3 members here who were on the board who agreed that they had standing, that if you made a judicial notice that they've been found to have standing, you'd save us all a nice long evening. And I know you were not here, but I think the 3 of them will vouch for what I'm saying as being a correct statement of the record in the case. We've had at least 4 appeals in this case that have involved all these people. So while Mr. Pettish and I may not agree, I'd like for that to be saved for whatever ultimate court looks at it. If you would make a judicial notice that they have standing, and if you would note his objection, we could all go home earlier. But I have folks here. If I need to put that evidence on, I will, but I would just as soon save you the trouble.
On the elements of granting a subpoena, you addressed relevance
Yes.
in some detail earlier, but there's 2 other elements, one that it be reasonable in nature and scope, and the other that it be not oppressive.
Yes, and I'm happy to talk to you about why it's both reasonable in scope and not oppressive.
If you would briefly.
What we have asked for from each of the individuals, so we're making some interesting arguments to you. Wild Flora Farms is the same as Wild Flora Farms LLC, and that's the same as Southeast Property Group LLC, and Kara Brewer is the same as each of these legal entities. And so what we have asked for is that if there was material submitted to the Department of Revenue, which I would think would be existent in a fairly easy way to reproduce it, that we be allowed to see what was submitted so we can understand to whom that certificate was issued and whether it's the kind of certificate it needs to be. An argument about what you can do in terms of looking behind DOR, I think is an argument for the hearing in chief. But certainly, you've asked questions, Mr. Herman, just in the few minutes you've been asking questions that really demonstrate the need for us to have those backup documents. The dates for these entities don't match the date of the certificate. The certificate was issued earlier than several of the dates for the entities we've talked about. Wildflower Farms LLC did not exist, for example. So it's unlikely that was issued to Wildflower Farms LLC, but I don't know. That's why I want to see the documents. I've not asked for, the legal relationship between Kara and Chris Brewer, they can put down wife and husband, no big deal. But if we are asked, as Orange County has been asked, to assume that Wildflower Farms is the same as Wildflower Farms LLC, and is the same as Southeast Property Group LLC, and is the same as Kara Brewer, and that income from any of these other legal entities somehow applies in that, I think it's appropriate for us to have that information to understand what was asked and who's who. And I don't think it's difficult or oppressive to seek a package of information that was provided, to seek a certificate that was then used to come before you. Mr. Pettish talked about privacy, and privacy is an interesting thing. If you're going to take advantage of the law that allows you to apply to NCDOR and get this certificate in order to use this farm exemption, then I think you have indicated your willingness for people to look at that information to support what you are arguing you're entitled to under the statute. We have not intended to ask for any deep, dark secrets. We're wanting to know what the request says is information for each entity, submitted or caused to be submitted to the North Carolina Department of Revenue and/or Orange County, its employees, agents, and attorneys. So whatever they gave to DOR and whatever they gave to Orange County regarding eligibility and compliance under these statutory provisions, as well as the relationship. What is the relationship between you? Are you a merged entity? Were you not a merged entity? And I don't want to know details about people's personal relationships. I want to know what they think their legal relationships are, because Mr. Pettish has argued to the county and now argues to you that somehow this is all the same thing. And so I don't think there's anything oppressive or unreasonable about asking you to pull out the package you already gave to somebody. The statement Mr. Pettish made that Mr. Harvey has all of this information is simply incorrect. You have what Mr. Harvey has. You have a certificate that doesn't explain exactly to whom it was issued. Did that answer your question?
Yes.
Thank you.
Quickly, we now have these articles of merger showing that Wildflower Farm LLC and Southeast Property Group LLC have now merged. We also have the assumed name certificate showing that Southeast Property Group LLC was previously operating under the assumed name Wildflower Farm. So even if there was an issue about the identities at the time that the letter was issued, it seems to me that it's possible it might be moot at this point, as the entities have all now merged. Would you like to address that?
I'd be happy to. The reason we have the subpoena is to answer some of these questions. The questions you were asking me presuppose that we know the answer to the questions in those documents. What I know is I know that DOR issued a certificate on 9/22/17 that's addressed to Wildflower Farm without an LLC attached to it and to Kara Brewer. What I also know that a month later, or 3 weeks later, I guess, 10/12/17, Southeast Property Group LLC filed an assumed name certificate, DBA Wildflower Farm, no LLC. I know that Wildflower Farm LLC was then created in February 14th, 2017, and that there is some kind of merger that occurred on February 19th, 2018. That answers no questions for me about what information was shown to DOR to show whose revenue was being used to determine whether they were entitled to a certificate or what that certificate was. And I would submit to you very frankly, Mr. Herman, that the document that Mr. Pettish gave you is excellent evidence of why we need to have the subpoena, so that we can understand how entities that did not exist at the time the certificate was issued play a role in whether that certificate appropriately applies to this property. If, in fact, there is nothing in the documents to call into question which entity it is and whether that entity is, in fact, the owner, which I would submit to you it still is not, at least not until the merger, which is well prior to this. If we look at the materials and the materials don't support anything I wish to argue, I suppose that would make my hearing somewhat shorter. But without the subpoenaed documents, how will we ever know? And all we're asking you to do is let us all know what we're dealing with. Let us all look at it. And Mr. Pettish can argue what it means to you once we've gotten to see it. He's seen it. I've never seen it, and neither have you. And neither has Mr. Harvey, and neither has Mr. Roberts.
I have one more question
Yes, sir.
quickly. Putting aside the issue of the identities, you've also talked somewhat about the length of time that income was supported. But looking at the statute, it seems to me that once the property owner, assuming that we have the correct property owner, once the property owner has brought forward a qualifying farmer sales tax exemption certificate from the Department of Revenue, the statute seems to require that the county is required to accept that and can't look behind it. So going, aside from the issue of the identity of the entities, what authority do you think we have to look behind the certificate that's been issued by the Department of Revenue?
Mr. Herman, I think that's an interesting question, and it's very frankly a question, I believe, of that's going to be a question of first impression, because the statute's new, and we don't, that's not been litigated as to whether a county has the authority under this statute as it is now written to look at what was submitted and look behind it to determine if it's appropriate. I'm not even there in terms of my thinking about what it is, because I have never seen a tax certificate issued to the owner of this property, either as Southeast Property Group LLC or as Wildflower Farms LLC. And so I haven't even gotten to the place to wonder the answer to that, because I think we have to get past the entity question first. I have no doubt that you can look past the entity question. In fact, I would submit to you that a simpler answer would have been for the county to look at it and says the property owner is Southeast Property Group LLC. They don't have a certificate done. I think that would have been correct. That's not what happened. What happened is the county looked behind the certificate, made an argument that the legal formalities of corporate ownership and individual ownership somehow have no meaning, and issued an opinion which blended together a bunch of legal entities. So again, it's hard for me. One reason I wanted to bifurcate the hearing is it's hard for me to answer questions to you until I can see what I'm talking about. But I am 100% certain as I stand here that you do not hold a tax certificate with the name of the owner of this property on it, even if we assume that a post-issuance merger somehow has play here. You just don't have it.
I got you.
I'm good.
Any other questions?
Thank you all. Oh,
That was quite a bit of time that Ms. Brown had. If I could have 60 seconds to make some short response.
Okay, it's 45:18. Carry on.
I want to point out that the question is, what would this board do with this information if it got it? With respect to whether or not, if this board starts going behind the Department of Revenue, there will be attorney's fees awarded to Ms. Brewer and SPG and Wild Flora Farm in this process, because that is absolutely outside the scope of this board's authority. With respect to the entities, again, if this board wants very specific additional documentation with respect to whether Wild Flora Farm and Wild Flora Farm LLC is what the Department of Revenue intended when it issued that card, that can be addressed. The rest of that is entirely unnecessary to determine that very simple entity question. Thank you.
Thank you, Andy. Any other questions before we close the public hearing?
Am I correct that regardless of what our decision is, it's going to be appealed to Superior Court, and this will be dealt with in Superior Court?
guess we can jointly respond. This is where we probably aren't so adversarial. This is uncharted waters. I think both of us agree, and it's not exactly sure how the courts will treat an appeal from this decision. I don't know if you can.
I think it's fair to say that whatever you do in this case will end up in an appeal somewhere, because there are, I think, at last count, 4 appeals, maybe, 3, 4. There are a lot of appeals. I think whatever happens, that somebody's going to appeal. I will tell you in no uncertain terms that I will have to appeal, because without the documents, without the subpoenaed documents, I think my hands are tied to even make an offer of proof to you. So I think, regrettably, Mr. Katz, it'll probably be appealed by somebody somewhere along the way.
That was my understanding. I anticipated that. And as far as the fees, et cetera, for this investigation into the tax records and Department of Revenue and everything that you alluded to, these would be directed at Ms. Brown's clients?
No, it would be it would be the county who would be liable for attorney's fees.
I see.
This is 6-21.7 of the
I
general
just
statute.
wanted to check that out.
May I respond by saying that the threat of the use of the statute for attorney's fees as a reason to inform your decision is troublesome to me. I do not believe, having read the statute numerous times, that it's a foregone conclusion that someone would get fees if you decided to grant the subpoenas. I will point out that anytime you are dealing with different parties, and each party has rights and responsibilities, and each party has the ability to seek legal redress, that you have to make decisions based on what you think is right or wrong, and not on any threat about that. But I don't read the statute quite the same way as Mr. Pettish, apparently.
I have a question. It'll be addressed to you. Theoretically, after you examine all the information that you seek, one of the primary determinations that I think I hear from you is that the planning department was an error in the decision that they made because they lacked the subtle understanding of the, let's say, chain of ownership, and whether they legitimately were in a position to make the request to be a legitimate agricultural entity by North Carolina statute.
Let me try to answer you.
You know what I'm saying?
I do. My view of it is that it was a pretty simple question. Who owns the property? Southeast Property Group, LLC. Whose name's on the certificate? Somebody else. That the county, at the request of Mr. Pettish's myriad of clients, did a pretzel twist to say that, well, this entity is really the same as this entity, is really the same as this entity. So,
So I understood that correctly. That,
yes, sir. I think so.
It was. It could have been a misunderstanding to actually grant what they granted, as far as that whatever entity it is that owns this property did not have to appear initially before this board for a special use permit, et cetera, and then was granted the use of this property to put the barn up in error.
Well, they appeared before you. You denied a special use permit. They appealed that. The appeal was not perfected. They then took the position that the property, the Southeast Property Group LLC, took the position that the property qualified for the farm exemption. We have a couple of cases about that. And then the statute changed.
Is there any case law that says anything regarding the fact that if an entity makes a request for a special use permit, they're bound by the results of that?
I think so, Mr. Katz. I argued to the board earlier that there's a collateral, they would be stopped from having proceeded with everything that's gone forward. And somewhere out there in all the myriad of cases is that. And if you look at the errors I've alleged in the case in chief, which you are not hearing tonight,
No.
I'll make that argument to you again. I'll come back. I'll make it again.
And during the course of these, what, is it 2 years? Something like that? Feels like longer than that, but it may be 2
Been a
years or
while.
something.
3.
Right, there's been an evolution of what the entity is that owns the barn. That is in terms of how they present themselves to us, what they farm, what they do, et cetera. Is there any, maybe I'm off base and you can shut me up on this. Is there any requirement for them to establish that they're a legitimate operating farm that has income and that continuous income while they do this business, which may or may not be appropriate?
May I respectfully request that we save all of that good stuff for the hearing on the merits when we get there?
Right. I was under the impression that this would be a very different kind of hearing, so I came in and I had to get it out of my
I'm
head.
sorry, and we had both asked for, there are a couple of reasons we both asked for this, and let me just be real frank with you about them. One reason that we asked for it to be bifurcated is that we both believe that this issue is important to deciding what happens next. The other reason we asked for it was out of courtesy to me because I'm having a bilateral knee replacement tomorrow, and having both of these things before us tonight was a bit daunting to me. So Mr. Pettish has shown me the professional courtesy of working with me on this, for which I am extremely grateful. I may not agree with him about very much, but I'm very grateful to him for being as professional as he's been about tonight.
Thank you, Leanne.
Thank
Good luck
you.
with your
Thank you.
surgeries.
I'm sharing that just to let you know that there's actually a reason that I really hope we can not go that far.
Okay. Any other questions before we close the public hearing? If there are none, is there a motion to close the public hearing?
I move that we close the public hearing.
Thank you. Second? All in favor, please say aye.
Aye.
None are opposed. Okay. Susan, what are you thinking?
Yeah, as much as well, first of all, I want to thank Randy for having such good questions and thoroughly covering everything that I was also wondering about, and Barry too. But beyond that, I don't, I'm squeamish at being overreaching, and I think that Mr. Pettish had very good arguments, or expressed very good arguments about that. However, I come down on the side of allowing the subpoenas to be issued. And I think that Barry made some good points, and and so did Randy. Without the subpoenas and without the information, that there are remaining questions to be answered. And I feel like that's probably unpopular. I don't know how unpopular it is right now until I look around and hear what everybody else says, but my position is going to be to allow those subpoenas to be issued.
Thank you, Susan. Randy, would you like to express your thoughts?
To the extent that we can rewrite the subpoenas to limit them in scope, I think there's two separate issues here, and one issue is the identity of the different entities and people that are involved, and then the other issue is everything else having to do with the history of operations and things like that. I think there's a legitimate concern about whether the correct entity, whether the entity that owns the property actually was issued the certificate that they used to show that they're a farm. And I think that's a legitimate issue for us to look at. The rest of it, I don't think we have any right to look behind what the Department of Revenue has done in terms of did they find the proper history of payments and things. I don't think any of that is within the scope of what we have the power to look at. So if it's possible for us to rewrite the request and limit the subpoena only to the specific issues of identity, that's what I think makes the most sense. And we may have to talk to our attorney about whether we can do that or not.
I have a question about that, because Mrs. Brown mentioned that there is perhaps a question about the qualifying financial information that was used to gain one of the certificates. And, you know, I don't know how that is unraveled when, you know, the question of the entities is resolved. But, and, you know, I'm perhaps on shaky ground thinking about that, but if information was given to acquire a certificate, and that certificate is then used to base a decision on, then if the certificate itself shouldn't have been issued, then the whole thing falls apart. And so,
Right, but I don't think.
yeah, you help me with that.
I think once the
because
certificate is issued, you know, even if theoretically in another case, fraudulent information was provided to obtain the certificate or something like that, I don't think the county can look behind that and say, oh, we don't think this is a proper certificate. I think once the Department of Revenue issues it, as to that entity that it was issued to, I think that's binding, and that's the end of the inquiry as far as the county's concerned. And so then I think the only question that we can really look at is the entity to which the certificate was issued the correct entity, the entity that owns the property, and therefore is the property exempt or not. But I don't think that, you know, even if the Department of Revenue miscalculated the amount of income and issued the certificate in error, I don't think we have any power to look at that. That would be my opinion.
Barry?
Well, to your point, seems to me, these are the kinds of data and information that we need to know and that will be argued before us at the next hearing that we have for these people. That I'm not sure if you are a lawyer and have a thorough legal opinion that what you say that there's no basis for us or for Ms. Brown to be looking into this is so. I think the idea is that she gets a subpoena so she can investigate all of this and see substantively what it is that she has to present to us the next time we meet and hear this. So I think she has a legitimate right to have this information to document one way or another whether the right entity had standing and was approved for it.
Just for the record.
We're going to hear a lot about this the
Yeah.
next time we get together with these people.
For the record, I am an attorney, but there's no case law that I'm aware of on the interpretation of the statutes. This is just based on my reading of the statute, which seems to be pretty straightforward, but of course, that's not always the way it works out.
We'll be
once it
citing
gets
this
into the
case a
courts.
long time.
Right.
Probably.
I'd
yes.
like to just state that I agree with Susan and Barry that we should allow these subpoenas to go forward for the reasons you both have stated.
So can I make a motion that we move ahead and approve the subpoenas
Thank you.
as was requested?
Is there a second?
Second.
Any further discussion? All in favor, please say aye.
Aye.
Opposed?
No.
Okay, for the reasons you've stated.
Yes.
Thank you. If there's nothing further, we are adjourned.
I'm sorry, there is something further, but I need to turn it over to Mr. Bryan in terms of the continuation of the hearing to a date, time certain to hear the merits of the case.
I don't know if we need to continue it. It wasn't on the agenda.
So I think my interpretation is that this is case number A318. It was a determination in October, appealed in November, and this is the first matter. You might consider it a motion or something like that. Regardless, I think there's also some practical considerations. Ms. Brown, as she indicated, is having surgery. So it might be nice to just give her that peace of mind that it's not going to be popping up on the calendar in June. But if the parties have something else in mind, that'd be great. If the board has got something in mind.
Do the parties have a date you would like to specify?
I'll let Ms. Brown address this first.
Sure. Well, first of all, I have copies of the subpoenas. If I can give those to Mr. Bryan, because then once they're issued, then what I would ask you to do is to set a date by which the documents have to be produced, and then roll a hearing out sometime beyond that to get us back before you. I would ask that it not be done in June, just in case. There's a week in July that my family has a vacation, but otherwise I can try to do July, and certainly by August I should be full of myself. So if we could get the documents and then have them ahead of time, that would be helpful too. Michael is showing me dates. So he's got August 13th, September 10th, and October 8th. And assuming I had the documents, let me check my calendar before I say that, but I think both of those are probably okay.
While Ms. Brown looks at that, it might be prudent to, the subpoenas as submitted have blanks for when they should be provided. It might be prudent for Ms. Brown to offer a date that she thinks that the other party can reasonably comply with that.
If we push the hearing out this far, I think that becomes pretty easy. August 13th certainly looks lovely to me. September 10th is fine with me, but it is Rosh Hashanah, if that may affect
I have
folks.
a conflict on September 10th.
Okay.
Well, maybe August 13th works for everybody, and we could get documents late June, early
So,
July.
Ms. Brown, if for some reason your recuperation takes a bit longer, is it possible that that would be an extenuating circumstance that we'd be able to continue this to a different date?
If
You're very optimistic about this.
If I can't do it in August, I will beg for mercy from you. How about that?
Okay.
And I know you're merciful, but I would like to move us forward if I can. So I don't want to be the cause of a delay to my clients beyond a reasonable date. But if for some reason, Mr. Katz, I can't be here,
Fine.
I'll let you know. October's getting on out there. That'd be just my thoughts on it.
Is there anything else, James?
A date for the compliance with the subpoenas. You wouldn't want it to be on the same date as the hearing, because you would want
Exactly.
Leanne to have time to review it.
What would suit you, Leanne, as far as that goes?
Ouch. Assuming it works for Mr. Pettish, if I had the documents end of June, that should be ample time, and we're in May now, so if he took 6 weeks to produce them, then that would give me about the same amount of time to look at them, if that would work for everybody. Would that work for you, Andy? Assuming that we don't go some other route, would that work for you, at least theoretically, as we're doing this tonight?
I take a different reading of 388 in terms of producing the documents in advance of the hearing. So I would object to producing those in advance of the hearing.
And it's the board's prerogative. I think as a practical matter, both parties said that they were going to try to appeal this as an interlocutory, meaning that they would go to some other entity. If you have a date so what happens is, let's say it's July 1st, right? And then he doesn't produce the documents. Leanne would have, by statute, a right to go to the General Court of Justice, a real court, and say, produce it. So it moves the case forward like that. But board's prerogative.
Yeah, let's give him a date.
What are we thinking? Randy?
Well, I know I'm already in the minority here, but it does seem to me that the subpoena, again, there's apparently no case law on this question of subpoenas issued by the Board of Adjustment, but it does appear to be a subpoena for a witness to appear at the hearing, and if necessary, for them to bring documents with them, not for them to provide documents outside of the hearing. That at least would be my initial impression of the statute. So it seems to me that maybe all that we can require them to do is to appear at the hearing with the documents.
And that would give Ms. Brown no time to interpret anything
Right.
before the hearing. I would object to that, and I would propose that we actually propose a date and let them hash it out in court, whether that's the case. But I would propose, what were we talking about, July 10th?
July
Or
1st.
July 1st. I would propose July 1st.
I'm sort of thinking on the fly, so forgive me if I stop midway, but perhaps there's going to be a board meeting in July. You could schedule this for that, understanding that it's limited in scope just for this. And I don't know if do these particular subpoenas ask for the people to be present? Leanne? So if it were only documents, then you could have the July regular board meeting for the sole reason of taking the documents, for which staff can then take. But it may be too convoluted of a solution.
And I do think that the request that was made for the subpoenas only refers to information. It does not refer to the appearance of witnesses. So I think that I would object to the inclusion of that in the subpoena as well. And if they were requiring witnesses to appear, we would need a much more specific list of questions consistent with the discovery rules for those representing entities appearing. That's not nearly specific enough.
Well, Andy, what I was hearing was that the documents be produced in the 1st of July for review, not that we would need witnesses then.
To the extent that I don't waive my objection to them being provided earlier, if that's the board's decision, I'm only referencing the witnesses. The documents I'm not addressing with respect to that July date.
Okay.
If I could just let you know, the subpoenas that were attached to my original request, which I have copies of in my hand because they have a December of 17 production date in them, ask that witnesses appear at the Board of Adjustment hearing on a date certain. And then on the second page, you ask that the documents be produced in advance on a date certain and actually contemplated in the document that we provided 6 months ago that they be produced in advance. Rule 45 allows that, and I think these are subpoenas like any other subpoenas, so I think it's perfectly appropriate for you to do that without. I don't think you have to have the machinations of having it before a hearing, because Rule 45 allows documents to be produced outside the courtroom and witnesses then compelled. So I think we should use that as guidance. Personally, save you a lot of trouble, us too.
Okay, so we're back to the date. Then originally, you had mentioned receiving those, the information that's being subpoenaed by the end of June. Okay, so we're back to that.
End of June, July 1, that's kind of the same thing.
From what I heard from Mr. Pettish, et cetera, and the back and forth, and then from Mr. Bryan, was that we could have, or we do have, a July 10th meeting? Is that correct? Was that the date? July 10th?
July 9th.
July 9th, right. And at that time, the documents could be on our agenda as a way to enable one side to actually have the documents before we actually have the hearing, so that there's a chance to consider what the chain of information is.
Yeah, I mean, so that, I would have to look at statute again, but like what Randy mentioned about it being at a meeting, and then Andy objected about it being outside of a meeting, that allows it to be at a meeting. I don't know if it's too convoluted of a process.
Too convoluted for this Board of Adjustment?
You know, I would have hoped that the parties would, especially since they said that they were going to try to appeal this to another court, that they could just agree to give the documents on a date. But I think that this addresses having it at a meeting, limit it for just the production of the documents, and have the people come the August 13th.
Sounds like a good plan to me.
Okay. So is there a motion?
I can, however, I mean, for the attorneys in the room, because I don't know, I hear Rule 45, I don't know what that is, but can this information be received outside a meeting of this board rather than calling everybody back together July? I don't mind coming, as you know, but, you know, can we apply that and not put in that extra step? Is that a problem?
So that is the part and parcel with the convoluted. I guess it's the wrong word, but if there's nothing on the agenda and that's the sole reason that everybody has to show up, it might be frustrating.
May I say that if we set it up as proposed, July 9th, August 15th, this is going to be appealed in a court. And when that appeal happens, this may be, some other agreement may come to fore, and that may mean that we don't really have to meet on July 9th. But if we have it in there, it becomes a talking point and the basis for coming to some resolution.
And I'll be there if that's what we do.
Yeah.
Okay.
Is there a motion?
A motion to have the information presented at a meeting of the Board of Adjustment on July 9th, with a further meeting of all the parties on Board of Adjustment on August 13th. I move that.
I'll second.
Thank you. Thank you. Any further discussion? All in favor, please say aye.
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 Any opposed? Thank you. Is there a motion to adjourn?
I move that we adjourn.
Thanks.
Second.
Thank you all for your time. Good luck, Lee.